Good evening, everybody. Sorry we're about 10 minutes late. It's the colleague, Mr. Brian Drew. It's 9/11 on what day of the week is it? No, Friday. Is it Friday?
It is Friday.
It's Friday. Sorry, 9/11. Coming to you guys, Brian and I here briefly to talk about an update. There's as typical when politicians speak, there's information out there that could get people in trouble, and I'm primarily concerned about mine in mine, but to the extent it might help other people across the state, that would be great too. As you guys are aware, we've got 3 cases pending, which have been consolidated now, and we're getting ready to file an amendment to that complaint to clean up a couple of things to improve. We'll also be adding in some other people as additional party plaintiffs on Monday. None of that changes. We are still proceeding. We're asking information that strengthens our case, and as you might expect, general and the politicians involved don't want to answer those questions. They're fighting every inch of the way to have to actually answer a question about the manner and the substance impacts people. So we're still working on that, and we'll continue. Well, before I get to that, as you guys are aware, the appellate court in Mount, approximately around 30 days ago, issued a ruling that said that the union was likely unconstitutional, likely being the key word. And they did that protection clause of the Illinois Constitution. And they also said that they likely believe there's a requirement issue as well, but they don't have the authority themselves that the appellate court law for that reason, or they seemingly would have based upon their language. And they strongly encourage to take that issue up. That opinion that was issued by the appellate court, legal analysis on every lower court in the state. So the only other court differently than that appellate court opinion would be the Illinois Supreme Court or some other appellate court for appellate districts in Illinois, because there are 5 of them, and 4 of them could choose to, but there is no other appellate court opinions pending on this gun issue that could choose not to follow it.
Tom, they're only getting about every other word of your audio now.
Okay.
Brian may get better audio. I don't know if Brian wants to try to recap some of it.
Go ahead, Brian.
You're cutting in and out bad with your connection, Tom.
All right, go ahead, Brian.
I'll try real quick. Yeah, so we are, we've got our case still moving. Got the 5th District Appellate Court ruled in our favor on the TRO. Things are going well there. Tom sent out a bunch of requests to admit, the discovery, trying to get the Speaker of the House, the President of the Senate to answer our questions. In fact, Tom and I even talked about wanting to get the deposition set up of the governor, Speaker of the House, President of the Senate, where maybe we could get all 5,000 of our clients together in a big auditorium and let them watch those guys answer, because you'd all be entitled to be there. Tom came up with that idea. I thought would be pretty good if we can get that done. Our difficulty a little bit is we have the case up in Macon County. It is they've got a ruling back, and Tom and I were talking earlier, and we both, in all of our years of practicing law, had a first, and that was the ruling came back in Macon County, and the Attorney General's office filed an appeal to take it to the Supreme Court within 2 hours. I've never seen it before in my entire life. They were ready to go. They're moving it up there as fast as they can, unfortunately. And that's what they're trying to do, is their plan, which they laid out, which was to get to the Supreme Court as fast as possible and not answer any of Tom and I's questions, is working a little bit. So it's working through the Macon County case. They're headed there. We are doing everything we can to keep our case pushing it. We're going to have some hearings based on their objections. So what happens is the discovery we sent out, none of the people in the government want to answer our questions. So they've objected to everything, saying they shouldn't have to answer, never should have to answer. And so they filed objections to try to slow this down, to delay it, to do everything they can to delay it. And we're going to set those objections for hearing as soon as we can. We've got a status hearing next week. Tom's set up. We're moving and continuing to push as aggressively as we can. It's a battle though, and we're doing everything we can to keep going after it. And at the end of the day, I think our case is going to continue to proceed. They're going to try to do everything they can to slow us down and stop us. We're going to, especially once the Macon County case gets to the Supreme Court and they can ruling back because they don't have any discovery, any other evidence. The judge made his ruling, which was on its face, which makes it difficult. So we're going to continue to try to do that. We've got Tom's in Springfield. He's giving another speech. He gets called to give speeches now all over the state. So he wasn't at home today. So I think that's why he's having a little bit of difficulty with the audio. He gets called to speeches all over. So I jokingly say that it's true. I mean, he's a conservative folk hero now in the state of Illinois. So he gets called on to speak all over the state for everything he's done. So I think that's where he's at tonight, headed up there to give a speech tomorrow to Lincoln Day dinner. So, but that's that's where we're at right now.
Ryan, is my voice still choppy?
Nope, it's good now. And go right ahead. Oh, you're back out again, Tom. Also, they filed a notice of appeal on the TRO, and they're now trying to go to the Supreme Court with that. Tom can really fill you in a lot on that, but he and I haven't had a lot of time to discuss that yet. We've been working on everything else. I do think that their attempt is to try to drag us to the Supreme Court as quick as they can with this, to try to get the TROs knocked down. Now, the judge in Macon County did rule that the statute was unconstitutional on its face, so that is a positive thing. Now, that has to do with the assault weapons ban as it relates to the 3 readings rule and the enroll bill doctrine. The court granted summary judgment in favor of the state on that. So that is a negative. And now they're coming back into Tom and I's case and going to try to stop us from getting the discovery and getting the answers. They've already filed objections saying, hey, you can't ask about this. You don't get to know anything. We're basically saying to us, we're never going to admit under oath what we did. And they're doing everything they can to hide from us and avoid it. The worst part about it is it seems like those in power, from the governor down through the president of the Senate, Speaker of the House, all feel like they don't have to answer to the people. And they do stuff at midnight, 2, 3 in the morning, and they're going to continue to do it. And they're taking every legal maneuver they can to try to stop us from getting them to answer that, and to basically answer all of you folks and to tell you what they've done. So we're not going to stop. We're going to keep doing it. On behalf of me, I appreciate all of you, what all of you have done it the right way. You came, you got an attorney, you got on Tom's case. And that's how you do this. You go to court and you fight. And that's what we're doing, and doing it the right way. So we're going to continue to do that. There's Ryan again.
Yeah, so Tom is going to be back on in a few. For those that don't know, Tom is on the road right now. I see lots of comments that, oh, he wouldn't be late to court. Why would he do this? Well, he's on the road a lot, and he's on hotel Wi-Fi, and we can't help that everything worked ahead of time, and now it's not having the greatest reception. So he's moving somewhere that he can use his phone, good reception, get us on. While we're waiting for that, I'll give you guys just a quick update where we're at with the consolidated case. We were down to about 30 people that were signing up. We were getting signatures to get that filed. So we sent an email out about that yesterday and trying to contact those 30 people. So if you did not get an email from me directly saying, hey, you're on a delinquent list, we have everything that we need from you guys for the consolidated case. And that was going to get filed either later this evening or first thing Monday morning for the judge to adjust and amend the TRO. It's not a new case that was filed. It's a consolidated motion between, Tom and Brian that just making an adjustment to the case and during that adding additional party plaintiffs to it. So it doesn't have to go through the full proceedings. They'll get that motion filed on Monday. I've been working on it with Tom, working on it with Brian. So those people that are waiting on that information and sitting here for that, that'll be done. We're just, like I said, we're trying to accommodate those 30 holdouts that we need those signature verifications for. So we will get those and get that filed for you guys. So hopefully that expedites and gets that done quickly for everyone that's looking for that note. A lot of those, for everyone that is in that consolidated case, that TRO does not apply to you yet, right? Until the judge signs the order and agrees to it. So we get those questions quite a bit. I get some questions. How long will it take? I see that over here. If the judge gets it on Monday, he could update the order as soon as then, but we would hope that it would be sometime early next week. No, it's not only 30 plaintiffs. It's 30 people that we're waiting to sign. So that's what that is. Brian, I guess Tom's coming back on, and for those that are waiting, what we're going to talk about this evening is Tom's going to recap the Calkins case, the Macon County case. He did kind of go over it a little bit there in the beginning and how that impacts our case. And Brian and Tom will, have a dialogue back and forth to explain that to you guys and give you the legal analysis and reasoning on that. So the list, I'm just going to answer a couple of questions that I can answer while we're waiting on Tom. The list of FFLs that you can purchase through, if you are a named plaintiff, if you're a named plaintiff only, the list of FFLs are on DeVoreLawOffices.com. You can find those on our case documents. And let's see, Tom, do we got you now?
I still downtown Springfield, capital of Illinois. It's so damn bad. I can't even do a basic video. It's the state of
Yeah, you're still pretty choppy.
Still bad. I've got downtown. I'm 2 blocks from and there's in this town. None. They all.
Okay.
But all those themselves is 50-year raised because of Illinois, but it's service.
When you get to a point, just let us know that you got good service, and I'll answer a couple of these questions that we have here. So again, the case documents are anyone named plaintiffs. As a reminder, all the FFLs, DeVoreLawOffices.com. You can download all the case documents. You can see a list of all the FFLs that are named plaintiffs, and access that, including all the temporary restraining orders. So those are there for case 1, 2, and 3. It's available for anyone that wants to download them and have them available to them. So I see Tom's back again. Do we got you better now, Tom?
Really, it's still kind of muffled. So I get out of town and field and these podunk towns with it, they'll have it.
Okay, I'll continue to ask some questions. I see some questions about Guardians of Liberty. We're sending those out to the people as we get them for the association. Again, everyone that has signed up as a plaintiff, you're a member of Guardians of Liberty. When we get that signature verification from you, we'll make it official. But hold on, I'm just looking at this over here. We'll make that official, and we can adjust that as necessary throughout the federal complaint process because it is an association. So we'll get that done for you guys. As far as the private community, for the ones that are asking about that, we're still working on that. As soon as we have the complaint finished for the consolidated case, that's going to become our focus to work on. And we'll do that. That's a good idea. Whenever Tom jumps back on, I'll have him turn his video off and see if he can do audio only as well. We appreciate that. So Brian, what do you just your take without recapping at all? You know, procedurally, where do you think we're at with all this? And I know when Tom gets back, you know, we can kind of talk about it. Oh, here he is again. All right, Tom, you got us.
Brian, or can you muffled for some reason?
Yeah, you're muffled. Why don't you try to turn your video off, Tom, and just try to do the audio only? Just shut your camera off and see if we got you on audio.
I just off.
Okay, why don't you...
link, Brian, or
Yeah, the link is good.
When the video works,
You're still cutting out with just the audio.
send me a new link, Brian.
Yeah, we'll get Tom on here in a minute. It's tough. Springfield's a tough place up there. I've been there. It's hard all over in there.
Okay.
Going.
I see a lot of questions in here. Is the temporary restraining order void for cases 1, 2, and 3? Absolutely not. It's still in effect. Brian, do you want to talk about that?
Yeah, the TROs are still in effect. We have those. They are going to remain in effect. Only the Supreme Court could undo those at this point in time. The appellate court, the 5th District Appellate Court, upheld it. And so we're in good shape there. So it hasn't gone any further than that at this point in time. So until the Supreme Court weighs in, we're still good. So everybody's still in good shape on all of our consolidated cases, doing just fine there. We was trying to look at a couple of questions. Now they have appealed. Now that I think I talked about it briefly, and I think Tom and I will talk about that a little more. They have appealed our TRO. That's a temporary restraining order. Basically, everybody involved in the 3 consolidated cases that the TRO has been entered, you're good to go. There he is.
Still.
We'll see if we got you now, Tom.
Ryan.
Yeah, can you hear me?
Every third word. Up an error that I mean, it is. It's
Thank you guys for your patience. We're just trying to get Tom where he can get on. It's not that simple as just calling Tom and have him use the cell phone, because then he's not going to hear Brian talking back and forth. So. Well, I guess, Brian, if you want to, I know Tom will probably be up. There he is. Hold on.
Yeah. There he is.
Is it change trying to turn to passion?
No, it's not any better.
I heard every second, every third word.
Yeah, why don't you try to talk and see if we can get you now, Tom?
Yeah, side of Springfield now have all moved that can afford it. So might have internet. I found where there's, I guess there's structure. Me to restart my phone. Text me.
Yeah, that's not going to happen. I think it's just going to be internet. What we're going to do, I guess, Brian, we could probably just end the live stream and when he's give it or maybe give it another minute and see if we can get him to get some good service. Unless you want to try to give a brief recap of today's events. Yeah. I don't know if you want to take it from the top and kind of
I can
go over it.
I can try. Let me. I mean, when Tom gets on, he can fill in any gaps or anything. So what's basically happened is in the Calkins case there in Macon County, they ran to summary judgment. So what summary judgment is it's they're saying that there's no question of fact at all, and because there's no question of fact, the court can rule based just on that. Well, so they had 6 counts. So a few of the counts that Calkins's case had to do with some of the procedural issues. Well, all of those procedural issues were ruled upon in favor of the defendants: J.B. Pritzker, Speaker of the House, President of the Senate, Attorney General, Governor, all of them. So they all went their way in this motion for summary judgment, unfortunately. And then as it relates to the assault weapons ban, that summary judgment was granted for the plaintiffs in that case. So
we got you, Tom.
Still never seen it. This is the first time like this, guys. I'm sorry. If I was staying in, they'd have internet service.
So this brings me back to a funny story.
No, I'm saying it.
What?
And I think
so I'm looking at the ruling here. I've got it up. So when it comes down to it, as it relates to the assault weapons ban, the judge found that it does violate the Equal Protection Clause and the Special Legislation Clause of the Illinois Constitution. He found that the criminal code was facially unconstitutional under the provisions of the Illinois Constitution, but there aren't any details. So the judge didn't give a lot of facts or anything else as it relates to that. So what has happened now is as it relates to those procedural issues we're pushing to get the Springfield to answer to everyone, that those have been found in favor of the state. The assault weapons ban has been found unconstitutional by the judge of Macon County, but that doesn't end it there. That doesn't mean it's now off the books for everybody, right, Ryan? It's still it is still in effect for everyone who's not a part of
what the hell?
TRO.
Hearing?
What?
Huh?
Do we got you?
You guys hear me?
Yes.
Man, you broke up.
Can you hear us, Tom?
Turn my video.
We had you.
How about I turn my video off? Can you hear me now?
Yes.
Really?
Yeah.
Well, you can't see my pretty face. I did. Did you tell him everything, Brian?
Not everything. I was telling them how the court has ruled in favor, found that the basically the assault weapons ban is facially unconstitutional.
You broke up on me. What you tell him about it?
Just that the court's ruled that way on the summary judgment motion without any facts, and that now they've appealed it. The Attorney General's office had to the Supreme Court, which they did it within 2 hours of the ruling coming down. So if there was any doubt that this isn't exactly how they wanted this to proceed, all of that them filing their notice of appeal to get to the Supreme Court fast within 2 hours of the ruling coming in tells you that this is exactly how they wanted it to go and expected it to go. But that doesn't change. The law is still in effect, except for the people in our TRO. The TROs, anyone listed there, are still good shape as it relates to that. Now it will go directly to the Supreme Court, because once a state court, Illinois Supreme Court, once a state court judge finds a statute unconstitutional, it's going to go directly to the Illinois Supreme Court. They've already filed that notice to do that. The AG's office has. So that's going to be the next place this goes. And we would have an opportunity to file some amicus briefs, which means other people who aren't in the case can actually file a brief and get to be a part of it. Looking at some of the questions, the TROs, those are the ones in our cases that we've already got the TROs entered on. Though for all of you, you're still just fine, and you're the only people who still this law doesn't apply to as of right now.
You're back. I'm out in the high rent district on the west side of Springfield now.
Can you hear us?
Yeah, I'm getting ready to pull into McDonald's. Hear me, Ryan?
Yeah, we can hear you.
Yeah, hold on a second.
As it relates to, will the Calkins case decision affect ours? The Attorney General's office is going to try to use that to stop us from forcing them to answer our request to admit about the 3 readings rule, the enrolled bill doctrine. Basically, and all that is when they bring these statutes at the last minute, gut one, throw in whatever they want, and then have it passed in the middle of the night. That's what we're fighting against, to try to get that stopped permanently. There was an adverse ruling on that in the case up in Macon County. That doesn't preclude us, because the Supreme Court can still weigh in, but it is giving a little bit of traction for the Attorney General's office to jump back in our case, file a bunch of objections, and say, we don't have to answer any of your questions about the procedural issues, the 3 readings rule, and things of that sort. We've already got the objections. They're coming, and there more are going to come. So this gives them an ability to delay, which is their sole goal in dealing with Tom and I, is they're trying to delay us as best they can. Now, it's not going to stop us, but we're going to keep moving forward, and hopefully the judge will rule against those objections, order them to answer, and we keep right on going, and we're not going to stop. So that's how it's going to continue to go. I talked to Tom earlier. I think Tom has every intention of filing an amicus brief in the Macon County case when it gets to the Supreme Court, to be a part of that one as well. Obviously, best case scenario is the Supreme Court upholds it. Like we talked about last time, that could be difficult under the circumstances based on the status of Illinois law, these exceptions and the equal protection claims. They can be a little difficult without having any facts or evidence going in, and just simply going purely on the face of the statute without anything behind it, which is what the AG's office wanted all along. They didn't want us to get facts. They didn't want us to get into all those issues. They want to go solely on the law and try to push that standpoint.
I got my McDonald's Wi-Fi now. Huh? Did you hear me, Brian?
I can hear you, yes.
All right, I got Wi-Fi. I'm going to go ahead and shut the camera off. Is it okay now?
Yeah.
All right. Yeah, I the thing that's important, Brian, to point out to people that this is trying to explain to people is that the judge in Macon County didn't issue a based upon any analysis. The judge just issued a ruling, firearms opinion in our case, and the judge didn't have any choice. He just pretty much saying the same thing that the appellate court said. And so there was no, which is exactly what the governor's office wanted. They wanted a lower court like they got out of the Macon County judge without there ever having been any opportunity to full issues. So, you know, and with all due respect to the judge in Macon County at all, he didn't issue any ruling of any significance. He just merely entered an order. It's very brief. It's like, what, a page long that just reiterated what, which is exactly what the governor's office and the attorney general's office were looking for. Basic bare bones argument in a ruling so they could go directly to the Supreme Court having to really answer any questions. That's, you know, so that the only legal significant ruling is that it gave the governor's office a quick path to the Supreme Court to change anything. So it's, yeah.
Yeah, it's clearly what's happened. They wanted a quick path to the Supreme Court.
That ruling about there's no.
You cut out there a little bit on me, Tom.
No injunction lane.
Tom, we're losing you again. Tom, we're losing you again. And for all the people on here that are making jokes of, hey, how can we not do this, and so on and so forth. Let me take you back to the days of the masking case in which we intentionally had intentional actors cut off our stream, interrupt it, shut down our accounts. So I wouldn't put anything past this stream as to why we're having problems at this point in the game. We've not had problems up until this point. So Tom's tried Wi-Fi at a hotel, cellular service, Wi-Fi at a McDonald's, and unfortunately there's and he's tried two different devices, an iPad and an iPhone. So we've pretty much exhausted most of the measures. Let's see if he's got that one. Hold on.
There we go. I turned it off again. I apologize. I'm never stay away again in my life. I'll never stay here again. It's unbelievable. Part that I freeze up on, Ryan.
Basically, the judge made a very limited. He made no factual ruling at all. He basically just made a ruling reiterating what the 5th District decision was in our case that Judge Vaughn entered. From there, we didn't hear anything.
Yeah, we lost you again, Tom. All right, guys. I think we lost Tom again. What we'll probably do is just reschedule this and get it when Tom can come back on and affect it. But I guess to sum it up, the point, there's nothing that has changed with the 3 cases that Tom has with Brian. In addition to, there's nothing that's changed with us adding our additional consolidated complaint plaintiffs. All of those still proceed independently. So I think everyone needs to leave with that understanding. Tom and Brian were just trying to explain the process of Calkins and getting this final ruling and its impact and its unusual nature in which it was achieved. And I think that's what's most important for people to understand, guys, is let's take the legal analysis outside of it. The way in this was achieved is very unusual, and I'll let Tom and Brian elaborate on that later. And it doesn't pass the muster test as to how we got here for a case of this stature. So
yeah, it would be different, you know, if this was just a regular lawsuit, a little contract case, and people are fighting. A quick summary judgment might be a good way. Hey, this is just the law. Let's get this over with and move on. We're talking about constitutional rights. We're talking about multiple constitutional issues that the legislatures, we allege, are violating them left and right, taking away people's rights. And And basically what's happened is this ruling by the judge has no factual findings at all. It's purely on the law, purely on the face of the statute. There is a chance that the Supreme Court could uphold the ruling. It could be unconstitutional and it could be gone for everybody. But that's going to be very, very difficult now because the Supreme Court's going to have no facts and looking only on the face of the statute. And in our case, what we're trying to do is get to the facts behind it, because these exceptions that are laid out simply factually, we don't believe are proper. And that's equal protection. Basically, equal protection is, am I being treated, are all of you that are part of this case, is everyone in Illinois being treated the same as these people who are accepted out? And that's kind of in a nutshell what we're really talking about. And with no facts at all, the state's going to say some things, and you watch. If you get a chance, go look at the briefs and you'll find in there, you'll see the Attorney General say multiple times, these people are trained. They're highly trained. They're highly trained. Well, our facts and evidence are playing out that these people aren't highly trained. They're not, and certainly not trained on assault weapons at all. And for most of them, very few or even have to have weapons training or firearm training at all to do for the exceptions they received. But there's going to be no facts before the Supreme Court on that. So if the Supreme Court says, well, all we have is the state's word that these people are highly trained, so if that's the case, that's good enough for us. And they could overturn the Macon County case solely on that fact that, well, the AG's office says it. And the Supreme Court's job is to look at every statute that exists that comes before them and try to figure out a way basically to make it constitutional. So with that standard, it's a very high standard to have a statute found unconstitutional in state court. And that's going to be, and without any of these facts, it reduces the chances. And that's what Tom and I were talking about last time. That's what we're really frustrated about. But we're going to keep fighting, pushing. We're going to file an amicus brief and do everything we can to say, hey, Supreme Court, even though, you don't have any facts, go ahead and find this unconstitutional. Because what we want is we want this statute thrown out. We'd love to get to do the other things we want to do, which is to try to help fix Springfield, try to help change the way they pass these laws. That's severely hampered now a little bit, but hopefully we'll figure out, and I think Tom and I figured out a couple ways to keep that issue going, and we're going to continue to do that. So, but everybody, hey, everyone in this case who's on this stream, that's part of this case, that's part of the TRO, you should take from this, it still doesn't apply to you. We're still on track. Your case is moving forward. We're doing discovery, and we're still fighting for you, and we're going to continue to fight for you. And hopefully I'll talk to Tom and let him take a look at things and talk to Ryan and see if we need to put something back out, or maybe you can put a statement or send something out to everybody, but we'll do it again. So,
yeah. And I don't know if you want to stick around, Brian, it's up to you. He is about 2 minutes away from solid Wi-Fi from someone that's letting him use it. But it's up to you. I can wait and hold down the fort, but
I'm here. I'm good shape. It's a Friday night. I mean, I wouldn't. I had dinner with the family, the kids, so I'm all good now. So I came back to the office. So I was in town and wasn't out of town. So it's not a problem. I don't mind waiting at all. This is important stuff. It really is, and I think that's the thing that is most frustrating for me, is the Macon County case, to just flippantly and quickly try to get it up there when flushing this out could mean a lot. Not just
there
for
we
this
go.
case.
I'm
There
back,
he is. They can only hope to slow him down. They can't stop him. That's
keep me down, baby. I drove 20 minutes. Hey, Ryan, we're going to reschedule this again for tomorrow. We can do it in the morning or something. I'm sure Brian covered most of it. When I broke up, Brian, we were talking about how with the judge in county, consistent with the appellate court case.
Pritzker still doesn't like you, Tom. You're still breaking out.
All right. Still breaking?
Yeah, you're still breaking out.
Damn it. Well, can we reschedule this and we'll do it again in the morning? I'll go
Yep,
freaking.
we'll reschedule.
Okay.
We'll reschedule it and do it again in the morning. I just want to answer a couple of questions over here.
Go ahead.
The people that are joining the consolidated complaint, we kind of talked about it, but several people keep asking about it. Once that motion is filed and accepted by the court, and then the judge issues an updated order, that's when you guys will be able to make your purchases, and the TR will be applied to you. It doesn't mean you, because of this Calkins case, that you guys are out of the running, like I'm seeing in this sideshow or in the comments over here. So
that doesn't even make any before, Ryan. If Brian or I don't say it, don't be assuming things, because it's Dan Calkins and you start talking about things you don't know about. So if we don't say it, don't assume it. Okay, on the internet, assume somebody says something and it's true. It just don't do that stuff.
Yep, absolutely. Tom will get it taken care of, and like Brian has already told you several times while Tom was off, everyone that is joining our cases, nothing has changed. They're moving forward as Brian has stated. So you want to reschedule again in the morning, Tom?
Yes. There is no statewide injunction. Dan Calkins doesn't know what he's talking about. The Freedom Caucus doesn't know what they're talking about there. It is wrong. It is 100% wrong. Do not listen to that. It's not trouble. The Attorney General's office knows that it's not true. So please don't listen. Inaccurate. I hope Brian talked about that a little. If not, I'm repeating it. If he did.
Yeah, I mentioned it some, Tom, but to make sure everybody knows, I think in the Macon County case, they made some statements today that this ruling now means that there's a TRO for everyone in the state against this. That's not the case. The state court judge.
It's not even remotely true.
Not even remotely true. The state court judge made a ruling, but it doesn't make it applicable to everyone until the Supreme Court weighs in on it. So that's where.
Absolutely. Thank you.
Yeah.
I mean, it's no different than when the Safety Act was deemed unconstitutional by the Kankakee. It wasn't until the Supreme Court of Illinois weighed in and says that we're going to put a hold on this law. So just because one judge in Macon County says that he issued a ruling that's not constitutional does not mean that it's just a free for anybody that tells you that is wrong. And again, I've seen Dan Calkins say it. I've seen those are politicians. I mean, lawyers. So please don't listen to that.
Yep. And for all of our FFL clients, please make sure you check your email. Tom gave explicit advice on how to deal with that. So please make sure you check your email for all of our FFL clients.
The Macon County ruling was to accelerate Brian and mine's lands. Dan didn't bring anything to the table in this case. They just accelerated our legal arguments to the Supreme Court before Brian and I feel that it was ready. And the chances of that turning out poorly are a whole lot greater than they are turning out good. The chance of it not turning out good, I'm saying it's a lot smaller than it probably should have been. So Macon County does nothing other than fast track this case to the Supreme Court. But Governor Pritzker and Attorney General Raul wanted. They wanted a fast track before any discovery was done. They got exactly what they wanted from Dan. That this ruling was today, okay? It was, in my humble opinion, and it was not a good day for the people of Illinois today. Could we still win on this quick shot? But it's not our best shot. And hopefully, we don't have to talk about that. A great day for the people of Illinois today. It was exactly what Governor Pritzker wanted. So if what Governor Pritzker is a good thing for Illinois, then, that's up to you. But in my opinion, it Ryan thinks, but I didn't think it was a good thing.
Yeah, I think anytime the Attorney General's office is happy with the result, it's not good for everybody else. Now all that's happened is they've expedited what the original complaint that Tom filed. They took it and they fast tracked it to try to get to the Supreme Court first. Now there is a chance that they could prevail, and if they do, they'll have taken Tom's work and prevailed with it. Good deal. But they've severely reduced the chances by not having the facts and the discovery we're trying to do. But we're going to keep doing it. And Tom will fill you in a little more about where we're at. But our cases are moving. They're going to continue to move. We're going to keep fighting. And
did you mention, Brian, that in the first time in your and mine's professional careers, we filed within 2 hours of that Macon County ruling getting filed? Brian, you guys, I have never seen that in my life, and I don't think Brian has either.
No, I think, the ruling came out, and I got the ruling I get an email of the ruling. So I get an email ruling in the Macon County case. And about the time I go to open it and take a look at it, we get a notification that there's been a notice of appeal filed by the Attorney General. Like I said earlier, that's a first. And Tom called. He said, "Can you believe we got that within?" I mean, the day hadn't even ended yet. I mean, they have 30 plus days to file that notice, and it happened same day. They were ready for this. It went down exactly the way they knew it was going to go down with the evidence they want. It's a purely legal argument now. That we'll see how it plays out. So we're going to keep fighting.
I mean, as you and I said, Brian, and we'll talk more about it later, that Dan could take our legal work and still win. It's possible. And you know what? He didn't do anything other than take somebody else's work, but that's okay. I'm shot. But the chances of us losing are a whole lot because of the quick rush. That's the biggest problem that I have. There was no need to rush. There was nothing to gain. You know why, in my opinion, and you know me, Brian, I don't give my opinion much. You know why I think there was such a rush job? There was such a rush job because the politician and started telling and making commitments and and promises to people that didn't. So now that the politician is in the hot box, he's running to the Supreme Court real quick, hoping that it goes his way in order to get out of the hot box. Because right now, or before this order, and even now with this, the people that he took money from weren't able to go buy anything. All in a hurry because of that. And so it's a hurry up and rush to the Supreme Court. Even Mr. Stocks today did an interview with Greg Bishop talking about resolve real quickly. And again, I'm listening to that and I'm going, I understand resolve, but quick resolve means that you still do a thorough job putting your best case. And if you're going to go too quick, it's because you need to hurry up and get an answer. So worst case scenario here is that the Supreme Court grants the governor, takes away people's gun rights because they weren't ready when they went there. Calkins was trying to say, well, we tried, but the Supreme Court said, sorry, we lose. That's what I'm hoping doesn't happen. I'm praying that doesn't happen, but it's still, as you and I know,
and that's the thing, we're hoping that your original argument and the argument we're going to continue to make, that this is on its face, this statute's unconstitutional. But we know legally that's a tough argument in Illinois, in state court. It is a tough argument. It's a tough fight, and the facts would have bolstered that a lot, the discovery. And it's not, we're not going to have that, but we'll keep going and see where it heads to. But that's the short version of where we're at.
Yeah. And again, we'll leave it with this, Brian, is for our clients, and I think they're all clear, but for people, just because this Macon County order got entered today, if you're a citizen of this state, you just want to go buy a weapon, you hopefully go talk to a lawyer, right? Brian and I don't represent you unless we do. You're our clients, so you've already talked to us. But if we talk to somebody, because you got these politicians out here talking about just make sure that you protect yourself, because I guarantee all of you listen to certainty that the Attorney General's office of the state of Illinois knows with this Macon County ruling that there's no statewide prohibition here and that want wherever they want. The Attorney General's office knows that with 100% certainty. So don't listen to these politicians, please. That's all I'm asking.
Yeah.
You don't have to listen to me, but I'm
And what Tom's saying is, for the people who aren't a part of our temporary restraining order, the TRO, the law still applies to you. Those people who aren't a part of our TRO, the temporary restraining order, who can buy guns, for everyone else in the state of Illinois, which includes me, because I'm the attorney, I'm not a plaintiff. If you go buy that gun,
I'm not a plaintiff.
Yeah, Tom, not either. If I went out tomorrow and bought one of these firearms that is on the list, it'll get reported. I'll have a state trooper or somebody at my door next day, and they can arrest me, and I violated the crime. That violated the law. So until the Supreme Court weighs in, nothing's changed. So just what Tom's really saying is, hey, you listen to us, listen to Tom, because we know this law. Tom's done this before multiple times. I've been in it with him, and we know what this is. So stick with us. As far as getting the information from that, because we represent you. If we represent you, if we don't represent you and you have a question, call an attorney, talk to somebody. Don't go out on the own, because they are going to try to make an example of someone on this at some point, and they're out there trying, because they've been to. Yeah. I live here in Benton, and we've got 7,000 people in this town, and they've been to our local gun dealer within 2 days of this law passing, and was in there looking at what he had, what weapons he had, who he was selling it to. So they are making the rounds. But it's
and neither Brian nor I are on these lawsuits. I think that should say something to you. I am not on this lawsuit as a plaintiff. Brian's not on this lawsuit as a plaintiff. First on his, you take that for what it's worth. So me not being a plaintiff in one of these cases, order out of Macon County today. Guess what? I will not be going tomorrow. I will not, because I can represent myself and give my own, because I'm telling you, if I went and did that, I could be charged with a crime. Am I going to get somebody? I don't know, but I'm telling you, in my legal opinion, I could get charged with a crime. I'm not going to go ask to buy one. And if Dan Calkins told me, Tom, I would look at him and say, thank you for your legal advice that you got out of your Cracker Jack box, but you're wrong. Attorney General's office, who I talk to, and those are good men and women that work for the Attorney General's office. They're good lawyers. And Brian and I fight with them tooth and nail, but they are smart people. They know that that's wrong, is out here giving people bad information. But again, they got bigger fish to fry. They're not talking tomorrow, I guarantee you.
Yeah. Yep. That's the case. But yes, if you are part of our TRO and you've been named and you've received an order that says you're part of the TROs, yes, those temporary restraining orders, you are allowed to buy the weapons. You're good. Absolutely. Now, it's getting harder and harder to find, because the retailers outside of the state of Illinois have kind of put up a fence and have started not selling to Illinois. So, I mean, that's how bad this law is. They've even, that was their intention all along, I think, to just really put a chill on this. Even when in the TROs, they're still trying to put a chill on this to scare the suppliers, manufacturers of these firearms, to not send them into Illinois. And I think that was their goal all along. And so, but when we ultimately get this whole thing thrown out, that'll end that. So,
I mean, the arguments that we're making, Brian, but the arguments that we're making, to the extent they get knocked out and Dan messes it up for us, worst case scenario, we can still make them in the federal court too.
Yeah.
They're not gone. It's just, we had such a good opportunity here, and we to deal with the way laws are passed in Illinois on a grand scale. Not the laws are passed that affect future future generations. We may lose that opportunity. Right?
Yeah, I've been doing this 23 some odd years now, and in all this time, this is my first shot. And I've had some constitutional claims. I've had some other cases. This is my first shot, and I think it's yours too, Tom, to get a shot at having legislators put their hand up, swear on the Bible that what they're saying is true, and take an oath, and then we get to ask them, did you follow the Constitution? It is an unbelievably rare opportunity we have to make the legislature actually answer directly to the people and to all of our clients and tell what happened here. And it's a chance to change how they do it in the future. And unfortunately, the Macon County case has put a big dent in that, and they're going to try to put the nail in the coffin on it at the Supreme Court's what they're going to try to do. And that's what's really frustrating for us, because we had a chance to not just overturn the assault weapons ban, we had a chance to alter the way they do business in Springfield, and that's been diminished.
Tell them, Brian, that's what need to tell the people. Go ahead and finish that thought, Brian. That's exactly what the purpose was of playing Dan Calkins like a fiddle, was to keep that from happening.
Yeah, they basically, the Attorney General's office all but said, yeah, we're not getting into your discovery. We're not. They have no interest in putting the Speaker of the House and the President of the Senate and the governor in a position where they have to, under oath, answer these questions about whether or not they complied with the Constitution. They're doing everything in their power to avoid it. And the biggest goal they had was to take the Macon County case, sprint to the Supreme Court with no actual facts. They didn't answer the complaint. They haven't had to answer this. None of them are on the hook yet. Purely legal argument, no factual argument. They got exactly what they wanted. And if they can sprint to the Supreme Court and pull it off with no facts and win, the next motion Tom and I are going to get is, you guys' 3 readings rule and your enrolled bill doctrine are out. You don't even get to ask them. And they're going to file motions saying you don't get to, you're done, you're out. And that's going to be one heck of a fight. It's a fight we're going to fight as hard as we possibly can in the courtroom. And we're going to do everything we can legally to keep that fight up, but it's going to make it harder. And the hope of the AG's office is they're going to make it impossible for us to do that.
Yep.
And that's just, and I think at the end of the day, to take from it, that's our frustration here, is to sprint to the Illinois Supreme Court when there wasn't a need to. There's temporary restraining orders affecting everybody that are plaintiffs in these cases. We had it slowed down. We had the state back on their heels. We were going to hammer this home, take our best case to the Supreme Court for all of you people and for everyone in Illinois. But now the guys in Macon County have sprinted to the Supreme Court without their best case. Now it's a case. It's an argument Tom and I have already made. It's an argument that we're going to hope prevails, but it's the most difficult argument to win. So we're going to be rooting for it to happen, because that's just good. It's good for everyone. But knowing on the backside that we're very, very concerned. But we'll keep all of you apprised of what's going on. If Tom wants to set this back up in the morning, I'd be more than happy to come on, and he can get in the spot and do that. Just know that he's fighting, and what Tom's doing there in Springfield, I think, is talking at a Lincoln Day dinner tomorrow. And what he's doing there is talking to people who are conservatives, who feel just like all of you are, that are our clients, and explaining to them the fight that he's taken to the governor, the fight that we're taking to the attorney general, the fight that we're taking to the legislature. And he's talking to people about it and explaining what he's doing, and traversing the state to really get people out and get excited, because your vote's going to matter. It does matter. And if everybody that's a conservative and everyone gets registered to vote, they go out, they vote, we can get rid of some of these people in office. We can get some people that believe in the Constitution, some good, solid, conservative politicians who can actually follow the Constitution, want to do it, and do what's best for the people. So we're going to keep fighting, Tom.
Brian, let's leave them with this too. Even if we are fortunate, back to the Supreme Court, and I think, again, the governor's people and the attorney general's people, I'm intelligent. Even if they lose the equal protection argument, and our argument carries the day, and they win that argument, that will still be success in general, because they'll be able to get around the bigger issue of the constitutional past. That's really the bigger issue for the governor and the attorney general and the legislators. They pass laws and have been passing laws for decades. Even if they lose the gun bill to the Supreme, they're going to try to get around and have a really good chance of getting around all of that constitutional stuff. To me, is a bigger goal, or as big a goal. Because even if they lose now with the Macon County case and the gun bill is unconstitutional, they're coming back saying, we're not continuing any of this, and we're not answering any of these questions, because because they do not want to answer those questions that could impact their legislative futures for decades, for the Speaker and for the Senate President. And a Macon County case and the Calkins of the world have done. They gave that golden goose Democrats of being able to, even if they lose the gun case, to stay away from those bigger issues.
Yeah. Oh yeah, and that's their goal all along. You're right. Even if they lose the gun case in the Supreme Court, based on the arguments you've made that the Macon County case is pushing, even if they lose on that, they'll still have won, because then they get to turn around and come back to all our cases and say, we're not talking about all this procedural stuff about how we do laws. We're going to go right back to business as usual. See you later. And they'll go right back to business as usual.
That's what pisses me off, because Republicans in this state group aren't intelligent enough to play chess with these guys. We're playing, and they're playing chess. And we've got these, and I'm sorry, because I'm getting pressed. We got Dan Calkins, and you got some of my friends in the Freedom Ends. They're playing freaking checkers and tic-tac-toe, and the Democrats are playing chess with, looking like a bunch of goobers is what we're looking like. And I'm trying to play a chess match with you, and I got to deal with these guys thinking they're really out here doing something, and they're posting stuff on, oh, we got a ruling out of Macon County today. And I just get so frustrated and so pissed that Democrats are laughing, going, you know what? We are 20 steps ahead of you guys. Keep on going. Right? You know I'm right, Brian. I'm freaking right.
I know. Yeah. And for anybody who wasn't on last time Tom and I were on, we tried to get the boys up there in the Macon County case to go along with us, come in together. Just quick recap on what happened last time. We contacted them, said, hey, come in with us. Let's consolidate all the cases. Give us 30 days. Give us 45 days, 60 at the most. We'll get this discovery done. We'll make them answer these questions. You guys can argue the case. We don't need the glory. You guys argue it. You put your names on the front. We'll all go up to the Supreme Court together. You make the argument with our best case. And they said, no, thanks. We're going first. We're going to take your arguments, and we're racing up there with them. And that's what they did. Hey, Tom, I appreciate you letting me be a part of it. So if you want to talk again in the morning, and Ryan and you guys want to set something up, you just let me know.
All right. Sounds good, guys.